is Ellen Yaroshefsky, and I'm pleased to be joining you to talk about wrongful convictions and prosecutorial misconduct, which is one of the major causes of wrongful convictions. My background is in criminal justice. I was a criminal defense lawyer. I then started working at Cardozo Law School, and we started the Innocence Project. Barry Scheck was my partner, and then he and Peter Neufeld went off and formed the Innocence Project. That was in the early 90s. And since then, I have been doing a lot of work on looking at the causes of wrongful convictions, notably prosecutors, and writing about what goes on in prosecutors' offices. Why does this happen? And what should we do about it? And I have a number of articles that I've written about the relationship between prosecutors and defenders, and looking at why prosecutors, for instance, are not held to discipline. Why aren't the people who are responsible for instance, intentionally withholding information from the defense when that results in a wrongful conviction? Why aren't those people held responsible? So let me start with this today. The prosecutor is the most powerful person in the criminal justice system, not the judge, but the prosecutor. And that is because the prosecutor, as the arm of the people, they represent all of us. They have the power to decide who to charge, whether to charge at all, what to charge them with, what information they should turn over to the defense, what recommendations they're going to make in terms of, for instance, will they offer a plea bargain to someone to plead guilty instead of going to trial? At trial, what information they're going to present, and then if a person is convicted, the recommendations to make at sentencing. So those are all the basic powers. Beyond that, of course, is the question of when someone presents evidence after they've been convicted that they might be innocent, what's that prosecutor's responsibility? So overall, they have all of those powers, right? They're not held responsible like civil lawyers or like defenders are when they've done something wrong, which is to say, you really can't sue a prosecutor because they have what we call immunity from lawsuits, except for in the investigative role. But generally speaking, you can't sue a prosecutor. And so it's up to them. And it's up to them to exercise this vast discretion they have wisely. We call them ministers of justice. And that is because they're responsible not only to the victim, to the community, to the defendant, to uphold the defendant's constitutional rights, but they're responsible for the entire justice system, if you will. So even though we think of this as an adversarial system where the defense lawyer has an obligation to represent their client zealously, it is up to the prosecutor, frankly, to decide what information consistent with the Constitution am I going to give that defense lawyer? What am I going to charge the person with? And what kind of trial shall we have? So when you think about it that way, right, what happens during the course of a process where people get wrongly convicted? Why do they get wrongly convicted? Well, one of the main reasons is what we call prosecutorial misconduct. The word misconduct really is somewhat of a misnomer, because when you think of misconduct, you're thinking of something done intentionally. And in the law, it doesn't matter whether the prosecutor did it intentionally or not. But for instance, if they're sitting on a trove of evidence showing that the person didn't do it, and somehow they never looked at a file, right? Or the police never gave them the file, it doesn't matter that they didn't do it intentionally, it's negligent. They're still held responsible. And that's what we call misconduct. So many prosecutors balk at the idea of saying you engaged in misconduct because they will say, well, it's negligence, it's error, it wasn't intentional. But from the point of view of the law, that doesn't matter. Because when we look at the definition of how you get a conviction reversed, there's a term called prosecutorial misconduct. And what that means in the law is either the police, who are part of the prosecution team, the police did something wrong, for instance, failed to turn over evidence of innocence, or the prosecutor did. And as I said, it doesn't matter whether that was done intentionally or not. So there is that broad definition of prosecutorial misconduct that I'm going to use that includes negligence and includes error, right? And you may say, well, why is it that a prosecutor is charged with prosecutorial misconduct. The most common reason that prosecutors are charged with misconduct is for failing to turn over information to the defense. And that information we often call Brady information, after a case in the United States Supreme Court in 1963 called Brady versus Maryland. And that case said that the prosecution, so there's a due process, which is part of the Constitution, it's a due process obligation to turn over favorable evidence to the defense so that they can prepare for trial. Think about it this way. If you fall down and you hurt yourself and you sue someone civilly in civil court, you get to bring them in and ask them questions in a deposition. You get all that information in advance. And so by the time you go to trial, you're prepared. You have all the information about the case itself. That doesn't happen in the criminal justice system. In the criminal justice system, the prosecution has all the information. They don't necessarily have to turn it all over to the defense. You may say why, it's a longer story, but that's generally the way our system works. The Constitution now requires that they turn over favorable evidence, and that generally means evidence that's exculpatory, or sometimes evidence at some point in a case that tends to impeach a witness, that information you can use about a witness showing this is not a person worthy of belief. And so what happens is there are many cases where the prosecution either intentionally or negligently fails to turn over that exculpatory information. Sometimes they hide it. You know the Michael Morton case, you've talked about that, right? Where they hide the evidence. There are other cases. There's a case called John Thompson in Louisiana, where the prosecution took blood evidence to his house to hide it and didn't want to turn it over. And that blood evidence, when it was ultimately discovered, proved that John Thompson was not the person charged that should have been convicted of the crime. So there are a few cases like that of intentional misconduct, but most of them, frankly, are negligent misconduct. And we spend years arguing with prosecutors and arguing among academics of how much is intentional and how much is negligent. There's a dispute about that. One of the judges in the Ninth Circuit, Judge Kaczynski, once said there's an epidemic of Brady violations in this country and only judges can put a stop to it. And I'm not so sure there's an epidemic. Many people disagree with him. You might say it's episodic, but in any case, there's lots of it. There's a lot of it, and it's responsible for many, many of the cases of wrongful convictions where the prosecution just didn't turn over the evidence. They hid the evidence. And you might say, why do they do that? Well, the most obvious reason is people want to win. Even though the prosecution's a minister of justice, when they hide things intentionally from the defense, obviously there are political concerns and they do it to win. But in most cases, prosecutors do it negligently, maybe because they're overwhelmed and they don't really look through their file. Or one of the other reasons it happens is what we call tunnel vision, which is to say, they look at a piece of evidence. Let's say Mrs. Jones was at the scene and she didn't see the person for a very long period of time. Prosecutor looks at that and says, oh, I've talked to Mrs. Jones, and Mrs. Jones, really, she didn't have any vision at all. Her eyesight was terrible. So I don't even think this is favorable. And by the way, there's a lot of other witnesses who actually think the defendant is the one who did it. So the prosecution convinces themselves that they have the right person, and they look at every other piece of evidence from that perspective. If we have the right person, we know that the defendant is guilty. And so we call that tunnel vision, because they're looking at everything from the perspective of the guilt of the defendant. Not, what if they turned over Mrs. Jones's statement? Would that be favorable to the defense? So there are many cases like that of tunnel vision where the prosecution doesn't turn over the information. But in any case, there's lots and lots there are many, many cases of prosecutorial misconduct. In many of these wrongful conviction cases, it's not just prosecutorial misconduct that's the problem, because when there's prosecutorial misconduct, they haven't turned over information, for instance, that they should. There's also usually a defense lawyer who hasn't done a very good job of asking for the information, of pressing to get that information. And so we have prosecutorial misconduct combined with what we call ineffective assistance of counsel. And those two together often are the reasons that we see cases ultimately overturned when they are due to, quote, prosecutorial misconduct. You may say, well, what about those prosecutors who intentionally hid evidence, like Ken Anderson, who ultimately became a judge in the Michael Morton case, like the prosecutor in John Thompson's case who ultimately died, right? Why aren't they held responsible? That's a subject unto itself. As I've indicated, you can't sue them under the law. And disciplinary authorities, that is to say, the lawyers are held to standards by internal discipline. In every time you're admitted to the bar, whatever bar you're admitted to, there's a disciplinary committee, and anyone can write to the disciplinary committee and say, this lawyer engaged in misconduct, and the disciplinary committee is supposed to consider that. Well, when we look at the cases over time, this is historic cases, 30, 40 years, there are rare instances in which prosecutors are ever disciplined. Partly, they're not reported. Why? Because defense lawyers are loath and they don't want to report the prosecutor because they feel like if they report them in this case, the prosecutor will hold that against their next client. And so they don't report them. Judges don't tend to report prosecutors either, even if they know that they hid certain evidence in a case, even if they're angry about it, even if they might decide, I'm going to name this prosecutor in an opinion saying they shouldn't have hidden this evidence, right? But disciplinary authorities don't do it either, often because they think, well, the prosecutor's office themselves are responsible for the discipline of the people who work there. We're not going to second guess what they do. Or because there are very few people on disciplinary committees who have prosecution background and they really don't understand the criminal justice system. In any case, over time, we've seen very few people, other than perhaps the Duke lacrosse case, which you may know about. There's a lawyer there named Michael Nifong. He was disbarred. But generally speaking, there are very few consequences for prosecutors. And so then you might say, well, if there are few consequences, why not hide evidence if you're a prosecutor who just looks at your job, not as a minister of justice, but wanting to win? Some people say, well, let's just look at the bad apples within prosecutors' offices. And there are some bad apples. The chief prosecutor tries to weed them out. But oftentimes, it's not just a bad apple problem. It's a systemic problem, which is to say, if you're in a prosecutor's office and the culture of your office says, you hold on to that evidence until you're absolutely required to turn it over. You don't have to turn it over 1 minute earlier because we're sure we have the right guy. We want to get that person convicted. If you're in that kind of an office, the culture is going to lead to more error and more misconduct when you fail to turn over information. That's a short overview of how this works within prosecutors' offices and why prosecutorial misconduct, police misconduct, is one of the main causes of error. You might say, well, what can we do about it? Well, one thing that we can do about it is change the system of providing information to the defense. It's called discovery. What information should a prosecutor be required to turn over to the defense? In many jurisdictions, they're moving towards something we call open file discovery. What that means is when the prosecution engages in their due diligence and they get all the information from the police, from the medical examiner, from all the forensics, they gather all the information. What they must do is they must turn all of that information over to the defense. That's called open file discovery. There are versions of it where prosecutors turn over more information or less information. But in jurisdictions that we've looked at, where there is open file discovery, it works very well. What does that mean? Well, when a defense lawyer now has the information, they can go to their client and they can say to the client, look, here's the information in the case that they have against you, and this is why the plea bargaining that they're offering to you may be something you want to think about, because if we go to trial, we're likely to lose. If the defense lawyer doesn't have that information, the client is skeptical of the prosecution, the lawyer is skeptical of the prosecution, and they may take the kinds of risks they should not, And there's mistrust as a result of not having information. I mean, imagine, I go back to your accident. Imagine you're in an accident and now you sue the other side and there's no exchange of information, right? You're not going to trust that the system is going to be fair if you don't know what information the other side has. And that's true here as well. So in jurisdictions with open file, there's not many studies on this, but we think there will be less prosecutorial misconduct. One, because the prosecutors tend to get more information from their police forces and they turn them over. And there's also quicker resolution of cases because now both sides know what is going on. So that's one. Second one, there's something called checklists. Not everybody can keep track of all the information. When you are running around handling many cases, you might slip up. And so it's useful to have a checklist. The checklist would say, here's the information I have, here's what I turned over, and it would be by category. And so in places where there are what we call Brady checklists, there's more likelihood that the information will be disclosed. Another route that's being used recently is a prosecutor's order to produce by a judge, a judicial order on Brady. And that's being used in a few jurisdictions, but it is important. It's been used by a judge in DC named Judge Sullivan. And that Brady order forces people to pay attention to what they've turned over, what they need to turn over, because a violation of that order can result in contempt. No prosecutor wants to be held in contempt. They will take that very seriously. Another suggestion is for the prosecution to always get the records of the police officer who will testify. That is to say, background records of whether or not any complaints have ever been filed against that police officer. And that those records, we'll talk about how they should be turned over and what parts of them should be turned over, but that many of those records should also be made available to the defense. This is quite controversial. It's a subject of ongoing litigation in various jurisdictions, but at least the notion that the prosecution should know, are they dealing with a police officer who has a long history of making false statements? Is that the officer they're dealing with, or is this an above board officer? Within prosecutors' offices, there are many things that can be done. First of all, when there's a reversal, when there's been a wrongful conviction, it would be very important for that prosecutor's office to sit down, not just with the lawyer who was responsible for the wrongful conviction, who maybe didn't turn over the information, but to sit down and examine, why did this happen? Let's get to the root cause of the problem. And once we get to the root cause of the problem, let's use this in training. We should constantly be retraining our prosecutors, our defense lawyers in our offices. And one of the things to use is the information that one gathers from these wrongful convictions. And if you go back and you retrain people, then hopefully that will work so that in the future, prosecutors will not make mistakes. At the end of the day, what matters the most, as I said, is setting up a culture. If you are the head prosecutor, usually elected, 85% of our prosecutors in this country are elected, right? If you are the head prosecutor, setting up an expectation that your prosecutors actually are there to do justice. They're not there just to convict. They are there to make sure the defendant is treated fairly, the victim is treated fairly, and that the community can rely upon what that prosecutor is doing in terms of turning over evidence, being truthful, offering plea bargains that really work, offering sentencing recommendations that they think are fair. And if you set up a culture like that, there's a greater likelihood that there will be fewer wrongful convictions. We are now seeing numbers of prosecutors around the country called progressive prosecutors or reform prosecutors who are being elected. And they're being elected on platforms of changing the criminal justice system, of reducing the criminal justice footprint, as we say, which is to say, in this era of mass incarceration of 2.2 million people in prison, mostly Black and brown people, disproportionately so. What can we do to reduce the number of people that we send to prison? And what they're looking at now are different charging decisions, not charging low-level crimes, not charging certain things as crimes, finding alternative programs, drug courts, mental health courts, dealing with the underlying problems that people face, which is why they find themselves in the criminal justice system in the first place. Changing policing, changing the ways in which prosecutors deal with the police force, like getting the police records, not necessarily relying upon the word of every police officer. Changing plea recommendations, not making the disparity between what you're offered in a guilty plea and what you might get if you go to trial so great. Because if what you're saying to people is, well, if you plead guilty now, you'll serve 5 years, but if you go to trial, you're going to serve 25, many people are going to be willing to take the plea bargain just so that they don't take the risk of that 25-year sentence, even if they say they're not guilty, and even if they know, and we later learn they're not guilty. So progressive prosecutors are looking at plea bargaining. They're looking at sentencing. We're looking at all aspects of our civil and criminal justice systems, but primarily criminal justice system, to ensure that the instances of prosecutorial misconduct in the future will be reduced. And I certainly hope that as progressive prosecutors work across the country, talking to one another, going out to their constituencies, and talking to the community, that the people that will be electing across the country will reduce prosecutorial misconduct. So thank you very much. I'm happy to take any questions.
Thank you so much, Professor Yaroshefsky. That was wonderful. You mentioned that you used to be a criminal defense lawyer, and one of the checkpoints in the system is that lawyer. And you mentioned that often there's a combination when the result is a wrongful conviction of both prosecutorial misconduct and ineffective assistance of counsel. If you're an aggressive, diligent defense lawyer and you run up against a prosecutor where you think there may be information that's been hidden, what can you do? Or that maybe an overworked prosecutor who's just not turning over as much as should be turned over, and you don't have an open file system in your jurisdiction. What can you do as a defense lawyer to try to protect your client in that circumstance?
Great question. This has happened a number of times, so that, Mike Morton is the primary case where the lawyer was a terrific lawyer, believed that the sheriff was hiding evidence because he couldn't understand why the sheriff wasn't going to testify, and kept going back to the court saying, Judge, we want them to produce Brady information. We believe certain information is this. You keep making motion after motion after motion. You try to get the court to ensure that they're ordering the prosecution to turn over specific pieces of evidence. You have to be very specific as to what you ask for. And you can go to, you go to the head of your office if you think it's that bad, and get the head of the office, maybe to go to the head of their office. I mean, these days, frankly, there's greater understanding that there is prosecutorial misconduct. And so the ways in which institutionally perhaps you can get the prosecutor's office to look at what's happened, not just the individual prosecutor. But at the end of the day, even the most diligent, terrific criminal defense lawyer doing all that can't necessarily uncover information if the prosecutor's office is just not going to turn it over. So, in many ways, you're between a rock and a hard place. You take a case to trial. There's nothing that's worse than believing you have an innocent person. It's very hard to represent an innocent client. Most defense lawyers will tell you they'd rather represent someone who is responsible for the act. Maybe they'll be arguing they didn't commit the act charged. Well, they'll say they can't prove it beyond a reasonable doubt. But to have an innocent client is so difficult, particularly when the other side isn't turning over information. So all you can do is keep at it. Keep asking the court, keep asking the prosecution, and make a good record.
Professor, we like to think of our criminal justice system as a particularly good one compared to many others in the world. And it's set up, as you said, as an adversarial system where you pit the prosecution against the defense with the judge as an arbiter and a jury as a decider of fact, and justice will occur. But you also pointed out that it's not really a fair fight, that the prosecutor is perhaps the most powerful person in that whole process. Um, for someone who's not part of the criminal justice system, and who wants to believe in a system that works and that is fair, what do you have to say to them?
We have to go back to the drawing board. There are many people who no longer call this a criminal justice system. We call it a criminal legal system because it's a legal system and justice is elusive. We have a long way to go before we get there. When you look at other countries in the civil system, I'll tell you the prosecution is also the most powerful person. In civil systems, the defense lawyer has a more limited role. They're just supposed to put forward evidence and present evidence to the prosecution. And at the end of the day, in most civil law countries, and they vary a bit, but it's ultimately up to the judge in many places and the prosecutor. So defense lawyer has a very limited role. As a structure, I think the adversarial system works best for cases that will go to trial, for people who are innocent. I don't think it works all that well when you have a person who admits that they've done a particular act. I'd rather see a system whereby the person who's responsible for that act gets some treatment. If it's usually we have mental health problems, we have drug problems. There usually are underlying causes of why people get into trouble in the criminal legal system. And it would be much better to be in a system whereby the person gets treatment. You look at Norway, you look at a lot of what goes on in Scandinavia. They don't have these draconian sentences we have here. People who are even convicted of murder, they go to prison and they get treatment. They figure out what's wrong with this person. How can we help them? There's nothing about our system that shows that we are helping people. We're warehousing people in prisons, often private prisons, that people do that for profit. And when a person comes out of prison, they have absolutely nothing. They have very few skills. They have little training. They have no financial resources. They have nowhere to go. We're not shoring up people in our system. So, many people argue it's a broken system. And while the adversarial system is a nice model, if we want that to work, we really have to go back to the drawing board. We have to change mandatory minimum sentencing. We have to change sentencing structures. Fundamentally, we have to look at the racial disparity. It's pretty shocking and it's overwhelming. The idea that most of the people serving time in prison are Black and brown people, particularly in drug cases, when the data show that as many white people consume serious drugs as people of color, but it is the people of color who are serving time in prison. So overall, we have a long way to go.
If you had a magic wand, if you were the head of the whole system and you could make changes in a wholesale way, what would you do? You've talked about the importance of open files. You've talked about creating a checklist system and within the prosecutor's office, the importance of avoiding tunnel vision. I know some prosecutors' offices have established what are called conviction integrity units to try to in a more systematic way, take a look at things that can go wrong and try to correct them. But if you had a chance to just rework the criminal justice system yourself, where would you start?
Changing resources. The prosecution and the police should not be the gatekeeper of social problems. That's what they are right now. Everything gets dumped into the lap of the criminal justice system. So if you have let's start with a mentally ill person on a street corner waving a knife, right? I mean, right now that person gets shot. I mean, this is what happens in many jurisdictions. What we should have community-based resources to go out and find that person and help that person. It shouldn't be that the police arrest them if they don't shoot them, and then they turn the case over to the prosecutor, and the prosecutor puts them through the system, and then somehow they plead guilty, generally speaking, because 95% of our cases plead guilty, and then they get some kind of a sentence. That does absolutely nothing to solve the problem. What we need to do is reorient the billions that we're putting into criminal justice systems, either through policing or prosecution, and develop strong community-based resources so that community people are involved in problem solving. That's a big ask. I know that people who use the term defund the police. It's a poor term. What they're really talking about is reorienting finances so that the community has the finances to begin to solve their own problems. And so we can start there. When cases come to a prosecutor's office, some cases need to be tried. I mean, there are just some cases that do, but I will say it's a very small percentage of what's now being put through the criminal justice system. So that's a huge ask. It's a huge reorientation. It's like turning around a battleship, because there are so many people who are paid through the criminal justice system who rely upon it. And this is the engine that works our social justice problems, but we have to reorient it all.
Professor Yaroshefsky, thank you very much. This has been instructive and helpful for our students and for me. And I appreciate very much the time and attention you've given to us and to the work that you do, both for your students at Hofstra and with it throughout the criminal justice system. Thank you so very much.
And thank you for the opportunity to speak to students. I always appreciate it. Thank you, Mark.